Okay, so the first session, which I'll be chairing, and my name's Amelia Fletcher. I'm an academic at University of East Anglia, but also on the board of the Competition and Markets Authority in the UK. I'm going to be chairing it, and it's on competition and consumer policy in platform markets. Obviously, as we've just heard, we all, platform markets are, for the most part, a great new thing. We all enjoy browsing on eBay, Amazon, we all enjoy searching on Google. Airbnb and Uber have completely revolutionized their respective markets. Easier search and comparison should be really good for competition. Things like Amazon and eBay have allowed lots of little suppliers to enter the market and gain an audience and gain consumers in a way that was very, very difficult in an offline environment. So lots of really good things for competition, for consumers, and all very dynamic. But as we've already heard, what we are beginning to see is some very, very large players, some network effects and bottlenecks, and some competition and consumer concerns. Tommaso said that the authorities were struggling to keep up. We'll see whether actually when you've heard from some of the authorities you agree with that. I think personally they're doing very well in keeping up, but it is difficult because things are developing very fast. So the idea of this panel is to chew through quite a lot of issues in the area of competition and consumer policy in a kind of roundtable discussion way. And one of the questions that we'll think about maybe towards the end, and it'll be good to get your views as well, is actually are competition and consumer policy as we know them sufficient, or is there any sort of need for extra regulation here in this environment, or tweaks to the existing policy? We may or may not get onto that, but have that in your mind. For this discussion, we've got a very excellent panel. We have Konrad Ost, who is the Vice President at the Bundeskartellamt. So you may well have seen him before. He's a lawyer by background, and he's been at the Bundeskartellamt for a long time, doing policy and litigation there. So he's very well versed in all of these issues. We have Andrea Coscelli, who is the acting CEO of the Competition and Markets Authority, and therefore I know fairly well. And he's been there for a little while as head of mergers and markets, and before that he's been an economic consultant at Charles Rivers Associates. So again, lots and lots of experience in competition policy and more recently consumer policy. And then we also have Christian de Cunha, who is the policy assistant to Giovanni Buttarelli at the Office of European Data Protection Supervisor. And this is actually a really interesting perspective into the whole debate, because he comes from the area of privacy and data security, and is very focused on thinking about how we bring together competition policy, consumer policy, and data protection as a kind of whole, where actually they've been considered rather separately in the past. So I think that'll be a really useful perspective to have in the panel. So how we're going to run the panel is we're going to start by asking Konrad to just speak, setting out some things that have been, some thoughts and some things that have been going on at the Bundeskartellamt. We will then just think about whether we have any initial reactions to what Konrad has said. We will then have two essential roundtable discussions. The first on competition policy, the second on consumer policy. We've got lots to say, I think. However, I'm also very keen to get your views. So maybe once we've got going on the round tables and have had a bit of a discussion, I will also invite your comments and questions. So please be thinking of things you'd like to say. Okay, I think that's enough starting. Konrad.
Thank you very much for inviting me to this conference, and thank you, Amelia, for the introductory words. Our first panel is on platforms. And my task today is to give you some insights into the machine room of competition law enforcers dealing with the challenges of competition law enforcement. The challenges of the internet economy. How do we see platforms? What are the new features? What are the new, if any, problems? Do we have the right institutional setting? Do we have the right tools? Is there another form of regulation needed, as it was asked? Let me start with giving the two answers. The one is digital platforms are a gift to competition and consumers, one of the best improvements of the competitive process for ages. So as competition watchdogs, we welcome platforms. We even act sometimes in their interest, in some cases. But the second answer is big digital platforms are seen as a major threat to competition. As enforcers, we have to make sure that markets stay open and that competitors and consumers do not suffer from the abuse of a dominant position. Let me echo a little bit what Amelia was stressing, the positive side of the platform. When we came to this conference, we enjoyed the advantages. We booked via a hotel booking portal, I guess. We searched for information about the panelists via the Google search engine. We possibly got into touch via WhatsApp to get a beer with friends or via Facebook. So it might be that a couple of different digital platforms helped us to have a more comfortable stay here in Berlin. Platforms provide information, they lower transaction costs, they help suppliers to extend their geographical scope, they increase price competition and facilitate communication. So wonderful. Platforms have the potential to intensify competition. But this does not always go down well with established market participants. Many industries have reacted and looked for ways to soften this competitive pressure. One instrument manufacturers have come to employ more and more are selective distribution systems. These systems foresee tight regulations for retailers' online sales, often with a view to making retailers' price setting less visible on the web. We have identified several restrictions in selective distribution systems that we consider illegal. For example, a ban on retailers to cooperate with the so-called price comparison websites. We had a decision on ASIC's case. Everyone knows ASICS, or the shoemaker. We have identified these kinds of bans as by object restriction of competition, and our Court of Appeal just recently backed our decision. We looked at prohibitions on retailers to sell via platforms such as Amazon or eBay, the so-called platform bans. Here we are quite skeptical too. In our view, they are just harmful as the bans on working with price comparison sites. But in this case, we did not decide on this issue, but it is pending before the European Court of Justice. There's a famous case called Kuti, and a preliminary ruling case is pending on this specific issue. So we're waiting for that. So far, so good. But today's conference is not so far about the positive sides. I think it's more about the dangers of big internet platforms. While you enjoy the advantages of the platforms, maybe at least when you have the bias of a competition lawyer, you ask yourself, did I pay a higher price for my hotel because parity clauses restricted competition between different platforms? Which data did I provide to Google in return for the search results? And maybe you got in touch with your fellows via Facebook or WhatsApp just because this was the only way to reach another. And you just hesitantly agreed to the last privacy update of the platform. Although it is undisputed that digital platforms offer multiple benefits for consumers, their impact on competition has to be critically assessed. For years now, we have an intense debate on how to deal with these big international platforms, these tech giants of our age. Maybe it's not by accident that specifically in Germany, there's a debate or even a kind of fear on the big platforms this fear provoked a debate by far transcending the competition law family. In the German debate, antitrust law has often more than purely economic connotations. Since its introduction about 60 years ago, the German Competition Act was the result of a very political debate. Very much comparable to the debate which led into the introduction of the Sherman Act in the 19th century in the US. The driving intellectual force 60 years ago was the assessment that private economic power is not only a problem for the consumer, it is also a problem for democracy as such. Based on these intellectual foundations, the fathers of the Competition Act saw undistorted competition as a solution to avoid too much economic power in the hands of too few. Competition as the, to quote, greatest tool for disempowerment in history, that was a quote of a famous ordoliberal thinker, was understood as a means to hedge powerful companies. And here we are again. In the digital economy, we have seen a lot of disruption. However, few platforms remain pretty stable or just increase their share. The famous GAFA, Google, Amazon, Facebook, Apple, these are the really big companies of our age. Amazon, for example, has a turnover nowadays of 100 billion, has more than 300,000 employees worldwide. Platforms are able to accumulate such a high degree of market power, particularly due to network effects and the accumulation of data. The more consumers use a certain platform to buy goods, book hotels, conduct online searches, the more attractive that particular platform is for companies that sell goods, offer hotel rooms, or are interested in advertising products. So it's a kind of a winner-takes-it-all economy. If at all, one monopolist-like company with a more innovative business model replaces another company, and only some form of competition in terms of innovation is left that a competition authority can protect. But isn't such degree of competition too weak compared to the idea of competition as a means of disempowerment? And is the control of abusive practices by competition authorities sufficient to safeguard reasonable market conditions? Abuse control is a difficult thing. Most of you will know it's burdensome and it takes time. Under these circumstances, it's not completely surprising that different stakeholders ask for regulation, some sort of regulation. It was undisputed and is undisputed that there were gaps in data protection, maybe in consumer protection. And these gaps were closed or are now going to be closed. But what about regulating the competitive behavior as such, like in energy or telecoms? A rather difficult example of frequent calls for regulation is the Google search engine. Some statements aim at regulating the algorithm that is the fundament of Google search engine. Regulating such a complex mechanism that is said to be amended hundreds of times a year is not particularly promising. And what would be the standard of the regulation when the aim of the algorithm is to detect and serve personal preferences? Looking beyond Google, you quickly realize that platforms have very distinct business models. A one-size-fits-all approach would thus not be very helpful. So regulatory measures are also not the best way to tackle novel problems that are not visible ex ante, which is particularly relevant in innovative and dynamic areas like the digital economy. So what is the position in Germany? What's going on here? The German Ministry of Economics published a white paper on digital platforms this year, in March 2017, and it's a rather bold statement that regulation is necessary. But when it comes down to the precise what to be regulated, it's not very precise as specific proposals are concerned. There are some areas which are pretty straightforward. The call for a level playing field for communication services is clear, and I guess it's right. But in the end, it remains vague, but there are other interesting topics within this white paper concerning more the institutional setting. There's a reflection on a new digital agency combining all sorts of regulatory, antitrust and consumer protection powers. The example of the CMA shows how beneficial it might be to combine more public enforcement of consumer law with antitrust. But I'm not entirely convinced that having even another authority beside our data protection agencies, the telecoms regulator, and us as competition agency, that there's a need for another authority. So in the end, I welcome the decision of the German legislator to empower the Bundeskartellamt with the task to survey the markets, not only on competition law, but as well on consumer protection law grounds. But again, general regulation, ex-ante regulation is necessary only when antitrust law fails. I will argue that antitrust law can adapt, will adapt, and partly adapted already. Well, the institutional setting. The institutional setting is good, I would say. We have a well-resourced European Commission, working in close alliance with national competition authorities. Most of them are well-resourced as well. And we have a legal framework which adapts. There's the 9th Amendment of our Competition Act, which will enter into force probably these days, quite exactly 60 years after the final deliberations of the Competition Act when it was created in 1957. And it will include, this amendment include important modification as to better tackle the issues of our internet economy. For example, by explicitly recognizing that there might be a market even in absence of money transactions, by including network effects and access to data as factors for assessing market power. There are still some discussions on further amendments, whether in the fast-changing world there should be more fast-track procedures like interim measures. But overall, I would say the toolbox looks rather right. If the setting is right and the law is good, why didn't you go after them? That's what competition authorities often hear by politicians. And then we have to answer, well, we did, but we did and do it carefully. It's a process. As competition authority, you should not design a market, but only react if something really goes wrong and you're able to prove it. Therefore, a first step for us was to understand the market mechanism. And we focused, we put much resources in that. We made a significant effort to build up solid knowledge. We set up a think tank in 2015, published various papers on platform and big data. But we didn't stop in kind of intellectual research or model development, but did a number of cases too. We had to assess a couple of merger cases in the platform economy. So a merger among leading real estate platforms. We had a merger between leading partnership platforms. We applied new criteria for dominance in the digital work, like network effects, access to data, the relevance of multi-homing or single-homing, and the likeliness of a marked tipping, where the market is about to tip. When the new law will come into force, we will have a new threshold and to get more mergers under our scrutiny. There will be a transaction-based threshold that is due to the fact that mergers like Facebook or WhatsApp were difficult to catch by our old regime. But in abuse cases, we did even some more. We gained experience regarding platforms in several proceedings. Although interventions that come too early may harm innovation in digital markets, and that's always where we have to argue with the other side, we found that interventions were necessary in particular cases to avoid that the market was closed. Our task is to keep the markets open. And the second is to protect the consumer. So what cases did we have? We have the cases on price parity. The price parity clauses or MFN cases where we prohibited best price clauses employed by the hotel booking platforms HRS or Booking.com. These clauses aim to make sure that companies selling via the platform, well, hotels or merchants, do not price lower on other websites than on the platform. Of course, it is a direct impediment to the seller's outreach to customers. Well, we had this not only on the booking platforms, but as well on Amazon Marketplace. We actually jointly did it with our British colleagues. Together with the European Commission, we had a case against Apple and Amazon concerning audiobooks. We, in that respect, we were already active, and in some respects, the companies gave up their practice. Finally, we have, in addition, our actual Facebook case. Here, I have to make it very clear that it's an ongoing case, so I have to be a little bit vague on that, and I'm not a member of the deciding panel, so everything I say will not bind the deciding panel. But anyway, it's an interesting case. It's an interesting case, and there's a suspicion that Facebook is dominant on a market for social networks. If the market definition of social network is correct, which just personally I find very persuasive, Facebook seems to be more or less the only important player. There are very strong direct network effects in this market. Consumers seem to be locked in. Everyone who is active on Facebook has this experience. So assuming dominance, which of course would have to be assessed in the proceedings, so it's just an assumption, then the question is whether Facebook commits an abuse of a dominant position by using its current general terms and conditions. One major concern of us is that Facebook's terms are simply not clear enough for the users. They cannot actually understand what happens with their personal data. To include such unclear clauses may constitute a violation of German privacy and contract law, the law of standard contracts or unfair terms. And such violation may in turn constitute an abuse of a dominant position. So from a European perspective, this is rather unusual, but the setting of illegal terms and conditions as an abuse, as a concept which is now pretty well known to German law. And it has been confirmed in 3 rather recent decisions of the Federal Supreme Court. Of course, not in the Facebook area, but in the general assessment of other cases, the Federal Supreme Court confirmed that there might be an abuse by unfair conditions. And then, if you see this, well, you have unfair conditions, and the interesting issue is then causality. The Federal Court, in its rulings, had a rather wide concept of causality without being, I have to admit, without being very explicit. There has to be a sufficient link between dominance on the one side and the breaking of the law on contract terms on the other side. But it seems that the imposition of the specific unlawful term does not necessarily have to be the result of dominance. It seems to be enough if it is detrimental because of dominance. Well, that's the German case law. Nothing comparable exists in European case law, but you have at least the reference to unfair conditions in Article 102 itself. Well, that's the German landscape. And you can see the work of the European Commission on the Google case, their sector inquiry. You have our French and British colleagues working intensively on competition issues of the platform economy. So if you assess our efforts in addition to the work of our partners in the ECN, I think we were pretty active. And if you allow the competition authorities to finish the big cases, for example, the Google case or our Facebook case, I'm pretty confident that in a year's time or 2, we will have a much clearer picture about the antitrust limits of the platform economy. But it's foreseeable that a conflict with these giants may bring up what the order liberals had in mind when they warned that private economic power may have political implications. It has the potential to provoke political conflict. Well, but competition law enforcement is not always easy. Let me finish my brief introductory words with a very nice quote, which I read in The Economist, reassuring competition law enforcement against platforms. It's nicely combining the two sides, the two aspects of the platform economy. Well, the economy writes, or foresees for the antitrust fight against the platform giants a battle on the scale of the one against Standard Oil in the 19th century. And then the journal goes on quoting John Sherman, which was a senator who gave his name to America's original antitrust laws in the 19th century. And he said, "If we will not endure a king as political power, we should not endure a king over production, transportation, and sale of any of the necessaries of life." And The Economist adds, "Even one that makes things very, very easy." Thank you very much.
Oh, go on. To the first of the roundtables, which is on competition. Lots and lots of different issues, as you've already heard, arising in the competition space. And what I thought would be useful to do is if Andrea now sets out briefly what some of the things that the CMA has been doing in this competition policy space. And Christian, maybe say a little bit of response to that, and then we will open the floor. So, Andrea.
Great. Thanks, Amelia, and thanks for the organizers for inviting me. It's a beautiful room and a beautiful city, so I'm very happy to be here. It's a very important area for us as well, and we have had various conversations with our friends and colleagues, the German Cartel office, with Konrad and his colleagues over the last few months and years. In many ways, I would say a fairly significant share of time in terms of discussions between national competition authorities, between national competition authorities and the European Commission, or I would say globally as well. A few weeks ago, we were in Portugal for the annual International Competition Network Conference, where essentially all the global enforcers are, and again, digital had a very significant share of airtime in terms of discussions. So why is it the case? I mean, I would say, firstly, because essentially commerce is moving in that direction. And secondly, because that's creating a disruption in terms of business models. So there are winners and losers. The platforms, obviously, some of the big names are big winners at this point in time, and there are obviously lots of losers. So in many ways, I think a lesson when you work as an enforcer is that losers are never quiet, in the sense that they, if suddenly their business models are suffering, they try to do various things. One is to fight, and the other is potentially to lobby interested parties about that and about the rules. Now, in a sense, if you think about taxis and the multiple battles between Uber and taxi companies all over the world, that's probably a very good example, because the lobbying power of the traditional taxi companies is very significant, but that kind of applies across the board. I mean, obviously, hotels are very important politically, and it's quite interesting that in an area like this, kind of ongoing discussions between the online booking platforms and hotel associations over the last 4 or 5 years, a lot of the discussions have been in front of competition authorities and the courts, but in a number of countries, when the hotel associations felt they were not getting significant joy out of the discussions in front of the competition authorities, those discussions migrated in front of Parliament. And in a number of European countries, national parliaments have now passed primary legislation banning some of these price parity clauses. So, we live in a world which is connected to many other interlinked parts. In terms of the debate in the UK, Again, I think probably UK and Germany are at the forefront of the debate. And again, I think this is linked to the fact that commercially, e-commerce plays proportionally probably a greater role in the UK economy, in the German economy than in other countries. And again, that's for a variety of reasons. A lot of, for instance, American companies ended up establishing their European headquarters either in the UK or in Germany, and they see the UK or Germany as the center for the kind of pan-European operations. And so again, I think it has been more relevant for the UK economy, probably for the German economy, and so we've had more of these discussions. There was a similar discussion in the UK last year about institutional design, whether we need a specific regulator, and some of it played in front of a select committee in the House of Lords, and it was a very good report actually published coming out of the discussion, which took into account lots of European input, which at that particular point in time, that was before the referendum and the sort of the Brexit discussions, was very much the competition law felt sufficient to deal with a number of these challenges because of the flexibility of the tools and the fact that the Competition and Markets Authority, we felt at the time, and we still feel that we have the tools we need to deal with it. And in terms of tools, I think there are many ways we are in a very similar position to sister agencies, but there are some extra benefits we have from our setup. So one is, as Konrad mentioned, we have both consumer protection and competition law powers, which in general we like, and we think it's pretty effective, and a number of other agencies around the world have the same setup, but we think it's particularly powerful in the context of digital markets. And the reason is that quite often in a context of digital markets, the problem isn't simply about just the sheer number of suppliers, but it's more about the rules of the game and the way these particular suppliers interact with consumers, and we think consumer legislation can really help to get better outcomes for consumers. And in many ways, personally, I feel quite agnostic about this institutional design debate, because I think at the end of the day, what matters is outcomes for consumers. Consumers obviously don't particularly care whether it's a competition agency or a regulator or a data protection agency delivering, in a sense, what they need. The vast, vast majority of consumers have no desire whatsoever to engage with the technicalities and the complexities of these platforms. They want the platforms to work for them, to deliver, and they think it's efficient if there is someone working to make sure that the rules are sensible. There's almost like some kind of refereeing, like arbitrator in the background who's making sure that the relationship between consumers and regulators is fair at some level. And in many ways, if I think about my own personal experience, I must be at the top end of the distribution in terms of my understanding of these platforms, but some of these things are extremely complicated. So when I look at my own personal behavior as a consumer in a number of areas, I just would like to have, a data protection agency or someone else taking care of it for me, as opposed to being forced to engage with the complexity of it. The second point, which Konrad mentioned, is merger control. Merger control matters in this area because obviously merger control tracks what happens in the economy, and M&A activity is clearly very important, but it's very important to keep it in check. Now, the UK historically had a flexible regime in terms of capturing transactions and allowing the agencies to look at transactions. So we have a turnover threshold like many other agencies, but those who have a flexible, what we call a share of supply test. So essentially we can look at mergers when we are worried that the acquiring company will acquire a significant share of a particular market. But we have quite a lot of flexibility about the way we look at markets. So the positive in all of this is we have historically been able, over the last few years, to look at transactions where potentially the turnover was very limited, but that transaction was for a lot of money, which is in a sense what Konrad was alluding to, that there was feeling in Germany and other countries there might be a gap if you see a transaction for 2 billion euros, very limited turnover, and somehow the competition authority is unable to look at. So that's a positive. The negative, which is a kind of a niggling doubt I personally have, is that when you look at ex post, some of the transactions we have seen over the last few years, we have seen some of these platforms buy startups that have turned out to be extremely successful. Now, Is it because they combined that particular startup with all the other assets and knowledge they had in the particular platform, and they essentially ended up with a different business, and this different business, Instagram or Waze, is a great business? Or is it because there is an asymmetry of information between very sophisticated technology teams in these large platforms who are looking around for potential targets with a very significant knowledge of their own platform and the potential gaps and the potential threats coming from new platforms, versus me or a few case handlers in a regulator who have a degree in economics or law, and who are trying to understand whether of hundreds of potential maps companies, the particular one that is being bought by Google is really the one that has that very significant technology and algorithms that potentially could be a serious competitor to Google Maps. And so that's a concern, but that's a concern, I would say, more about resources and knowledge and skill set than the tools and the design. So what we are currently discussing at the CMA, copying a bit what our colleagues in the US at the FTC are doing, is to try to set up a small data unit, trying to recruit some technologists to the CMA to complement our significant resources in terms of economists and lawyers and other specialists. And that's and the other thing that this FTC is doing quite well is combining that unit with strong collaborations with academic institutions, where essentially try to offer sabbaticals or try to get recent PhD students or postdocs in data science, in computer science, to come and spend some time in the agency to try to create some cross-fertilization of ideas. So that's certainly something we're looking at right now at the CMA, and luckily we have the flexibility in the way we can run the agency potentially to do that. So that's something I'm quite excited about. The third thing I wanted to mention is that also we have the ability to do sector inquiries like the European Commission and like a number of other agencies, but also potentially to take them further and have what we call this second phase, this market investigation, where potentially we become a quasi-regulator and we can impose some remedies on particular industries. So that's a useful tool and potentially can, from an institutional point of view, bridge the gap between the question of, are you just a competition agency or do you need a regulator? So we think that, again, is a good advantage we have. I mean, personally, I worked 5 years as a regulator in the telecoms and media regulator in the UK. And so, again, I think regulation can help. And in many ways, I think there is never a binary discussion between competition policy and regulation, because there are always regulations and rules anyway. So the question is about how many layers of regulations you need. And I think the experience of regulating infrastructure and bottlenecks over the last 30 years is that when the problem is very well defined, ex-ante rules, so rule-making, can be quite helpful, because in a sense our world of competition is a world which is very litigious, very exposed, and it takes time to fix things. So when the problem is well defined, ex-ante rules can be pretty powerful. The problem is, the problem needs to be well defined. So at this point in time, we know that if there is a single electricity network in a country, it makes sense to regulate access to it. But platforms change all the time. And as Konrad was saying, it's very difficult to imagine what exactly you regulate in a platform. And secondly, you need mechanisms where regulations are quite frequently looked at and changed and modified to keep up with change. And again, in this dynamic digital world, things change very frequently. So again, there is a real risk that you put in place rules that become out of date quite quickly. So in terms of what we're actually doing at the moment is, in a sense, very similar to what Konrad was saying, which is so we have a number of cases in the digital platform space coming to us on merger control that we're looking at. And that's an area where I think we feel pretty confident that our assessment of market power on platforms, I think, is fairly robust. And I think in response to what Amelia was asking earlier, I think obviously network effects matter, dynamic competition, it's case by case, but I think what is very important is to constantly mine the evidence, to constantly mine what's happening, to look at the last few years, to look at analyst reports, to look at what these companies are saying, to various stakeholders and to really understand the sources of market power there. So I think on merger control, there is an increasing part of what we do, and I feel pretty confident about it. Then there is the area of kind of horizontal agreements and algorithms, which is a very important area. There's a very good paper produced for the OECD meetings later this month, which is a background note on algorithms. That's an area all of us are interested in, and I think some of the speakers later today are going to talk about. That's an area where I think competition agencies are very interested, and I'm very interested to hear from academics, from people who are spending time on it, and obviously to understand what's actually happening in the companies and in the businesses now, which we know is a very important part of it. We had a case last year, which was a parallel case to the DOJ case, which is cited quite frequently at events now, which is it was a collusion on Amazon Marketplace for the sale of posters. And so this was essentially a traditional cartel, but was implemented with fairly sophisticated pricing software. And so it was companies in what you would imagine is a fairly fragmented, fairly commoditized market who had explicitly agreed to set up pricing software that would prevent any form of price competition between the companies. There was a leniency applicant. We did an inspection. We got quite a lot of good evidence. So as a case, we managed to finish quite quickly. And we also imposed a director disqualification order on one of the directors of the companies involved, which we think is an important step in terms of, partially in terms of deterrence, but in terms of making sure that people who engage in cartel activities are not acting as directors of companies. The big question there, as it's in the OECD paper, is, well, is it just the tip of the iceberg? You know, are there lots of traditional cartels being facilitated by these mechanisms? But also the other big question is, when we see as a symptom that in some reasonably concentrated industries, the outcomes are not great and potentially are worsening, is it possible that parallel conduct through algorithms is really one of the causes of it? And obviously, a number of our US colleagues are mentioning airlines in the US. Airlines in Europe of late are not great in terms of outcomes either, so that's another area of potential interest. And so I think this is a big question and certainly an area of big interest to us. Second area, very quickly, we're doing a sector inquiry, what we call a market study on price comparison websites. Again, we call it digital comparison tools, just to try to be slightly broader. And it's looking at a number of practices. On the competition side, obviously the areas of interest are these price parity clauses, MFNs, across a number of areas. We banned them on the car insurance market a few years ago, so we're looking at the effects of it, just the wide ones, not the narrow ones. We are looking at a concern that a number of people have brought to us that if we allow the narrow clauses, i.e. if we still allow, let's say, an insurance company and a price comparison websites to agree that the insurance company, if you go direct to them on their website, cannot discount from the price that is offered on the price comparison websites, whether if that's sufficiently present across suppliers and across price comparison websites, the actual effect is the same, almost the same, as having the clauses across all channels. So that's an active area of interest. Another area of interest for us, which again has come to us through complaints, is potential agreements in respect to bidding on AdWords, on Google AdWords or Bing AdWords. So it's agreements between suppliers or between comparison websites not to bid on each other's name, or potentially not to bid on anything that includes each other's name. And obviously, the wider you go, the more problematic it becomes for us, because obviously you can imagine as an entry strategy that you want to try to pick up potential consumers who are interested in competing brands. So the more you restrict yourself from potentially using that strategy, I guess the more worried we become. So that's another area of active interest. And finally, the final point I would make is again about timeliness, this issue about interim measures. So if someone comes to us and complains about potential exclusionary behavior by a competing platform, obviously time matters in these markets. So a couple of days ago, we published, we asked for comments on some draft commitments offered by a platform in an online auction platform that is supporting a number of smaller auction houses. So in the UK market, obviously you have the Christie's and Sotheby's as the big auction houses selling lots of things. They have their own in-house sort of online capabilities. But there are third-party suppliers to all of the smaller auction houses. You know, there are many auction houses in various towns and villages selling antiques or various other types of goods and services. And what we think is the dominant platform had various conditions in place, essentially price parity conditions that made it really difficult for new competing platforms to establish a foothold in the market. So there was a flavor of a sort of exclusive dealing about it, essentially making it really difficult for others to contract with the customers. So we looked at it. We were interested in potential interim measures, and this, what we think is the dominant platform, offered us commitments essentially to stop enforcing all of these clauses. And we decided, again, timeliness is quite important. It would be quite useful to try to get the market in the right place quite quickly. So we are consulting right now with a view to try to finish this case in the next few weeks. So again, there's always a trade-off between deterrence and timeliness. And, you know, do you go all the way? You try to have an infringement decision, which is also a precedent, versus, you know, do you try to fix the market for competing players? So it's a very active area across the piece for us. And in many ways, I think the way I feel, and I think probably the way the board feels, is that, you know, we really need to work hard to not to feel that we are kind of behind the curve in this area, just because of the sheer complexity and the sheer dynamism on the business side in this particular area. Thank you.
Thanks, Andrea. Okay, Christian, would you like to make any opening comment on the competition side?
Yeah, first of all, thank you very much for the invitation. It's been really fascinating and enlightening to listen to you both. I enjoyed your presentations. I fully agree with Andrea that what's important in all of this debate is outcomes for individuals rather than labels and what area of law applies to what behaviour. But the importance of this topic for me and for us as people active in the data protection space and human rights is that for most of us, for most people today, most of our internet experience or most of our experience of technology is mediated by platforms. So the question then becomes, well, who is really benefiting from the technology? And then we get into an analysis of what is happening in the market in which these platforms operate. Some of them are phenomenally successful. And it's, as I think Konrad alluded to in his speech, there has been an enormous amount of consolidation, if you like, in the big data area. So mergers and acquisitions, of sort of companies which rely on processing massive amounts of personal data in the last 10 years. To the extent that even though they tend to say that the markets are very dynamic and dominant companies come and go, actually the dominant companies today have been dominant for at least 10 years. So there seems to be a level of consolidation there for big data, but also now in artificial intelligence, there is an enormous amount of mergers taking place and acquisitions of startups who are working on AI. It's not only the entities which are emerging from this consolidation, it's also a question of consolidating Andrea alluded to this, the skills of people coming out of universities, that they're snapped up very quickly by these big platforms, and there is a concentration of IP and general talent. And then the third aspect of the consolidation, which is less less talked about, but I think there is now some interesting emerging research on this, that there is a lot of these platforms are characterized by common ownership. There tends to be similar, for publicly listed companies, there tend to be the same sort of names behind them, having a controlling stake. So that itself is a competition issue. There are the main concerns I think that we would have as looking at it from an individual consumer perspective is that there are with this sort of digital turn in the economy and society in the last 20 years, there have inevitably been what we would describe as externalities, just as in previous industrial revolutions there have been unintended consequences, and some of those externalities are being increasingly written about and looked into. I might just suggest a few. The fact that these platforms are competing for attention and eyeballs, that they are often designed platforms as applications or even and also devices which are used to access those platforms. They are designed in order to create addiction, to make them so attractive to people that they just don't want to put them down. So that's one possible concern, and that can be understood as being a privacy issue, that you only have a limited amount of attention, and if your attention is being absorbed by an addictive service, then that becomes a privacy issue. A lot of focus, especially in the antitrust community, on the use of personal data, and of course these platforms have become so successful to a large extent as a result of the accumulation of personal data, and that in itself creates not just concerns about surveillance and chilling effects, but also data security vulnerabilities, which we might come to later. And then a third aspect is, which has really hit the headlines in the last 12 months with the Brexit referendum and the US presidential elections, and now also in the UK with the current general election. The effect that a lot of these services may be having on democracy itself, which is why I was very interested by what Konrad was saying, in that we may be going back to, in our analysis of these tools, including competition and consumer law, how we can use them in order to safeguard democracy and freedom of expression. There is just two final things. There's often, I find that this extremely interesting debate is often sort of sidetracked into something which is perhaps less important, which is the question of whether targeted advertising is a good or a bad thing. Whereas what we think is we deal with human rights, and what consumer organizations think is that the problem is that you're being tracked, that you're being constantly monitored, often without you knowing about it, and often without your agreement. So that's the main concern that we would have, the main concerns. And the final thing is that the motto of Silicon Valley has been move fast and break things. And another motto has been we want to make the world a better place, we want to change the world. Well, they've actually succeeded in changing the world, and so we think it's now time for us to make them responsible for the changes that they've made, and to, pick up any damage which they may have caused in the process.
Thanks very much. Okay, so I'm going to go back through some of the competition issues that have already arisen, and just see if there's other thoughts that anyone wants to make. The first one is actually around algorithmic collusion, where I think there's going to be a big discussion on algorithms this afternoon, but I think that's going to be mainly focused on the individualization, so the individualized targeting, individualized pricing, those sorts of factors, and tracking, and maybe some of the democratic aspects as well. But this use of algorithms to facilitate collusion is really an interesting one. The US-UK case was easier, as Andrea said, because actually there was a clear explicit agreement to use these algorithms to have a cartel. But actually there are examples of people ending up with very odd prices by accident because they're using algorithms for pricing. So, for example, you've probably heard about the academic who told his student to go and buy one of his old books online because he thought it would be useful. The student came back the next week and said, I really didn't want to buy your book. Did you realize it's like $4,000? And the academic said, what? I didn't think anyone wanted to buy it. And it turned out the reason was, as you probably know, that Amazon was selling it on Amazon in its own right, but there was also a third-party seller selling it on Amazon Marketplace. They both were using algorithms. So Amazon thought, you know, I can't price all of these old books. There's a big tail of books, and I don't know what they ought to be priced, so I will just use one of these specialist booksellers and match their price. Meanwhile, the specialist bookseller thought, well, Amazon know what they're doing. Therefore, what I'll do is pick their price, but I'll just add a cent. And then they reiterated every day, and you can obviously see what happens. Now, that is not sensible pricing. That clearly was not deliberate. But it immediately shows that if people use algorithms, then even accidentally, they could reach fairly outcomes that look pretty much like a cartel, without any examples of or evidence of explicit cartel behavior. And if they hit something that looks like a cartel and no one does anything about it and they're all quite happy, then actually who's going to ever change the situation? So, I mean, obviously, if it goes up to $4,000 and no one buys it, then you might want to change the situation. But maybe you could imagine more sophisticated algorithms that just get everyone to a comfortable place. So in that context, it's also worth noting that increasingly, as I understand it, people are using these sorts of pricing algorithms if they've got large amounts of products. If you sell on Amazon, you can very easily buy pricing algorithms to help you, the little software packages. On Airbnb, my understanding is that they actually recommend that you use their pricing algorithm, and indeed you can only get certain placement on the page if you have used their pricing algorithm. And there are also other platforms which say that you can only go on the platform at all if you use their pricing algorithms. So I think there's some very interesting questions here about the use of pricing algorithms, cartels, and the role of platforms in all of this. And I note that in financial markets and financial actors are meant to provide information to the financial regulators if they see things that look like suspicious transactions. This is in the context of insider dealing or market manipulation. Question mark, should platforms have any responsibility to inform you guys if they see suspicious transactions? So I don't know whether either of you have any views on anything there.
I mean, if I can start, I mean, obviously there's the issue about pricing on platforms. Personally, I'm probably slightly less worried about very fragmented markets. So as I think about Airbnb, to think about the degree of fragmentation, I mean, what worries me potentially a bit more is the interaction of merger control and algorithms, which is that over the last 10, 15 years, I think many competition authorities have allowed a fairly significant degree of concentration in a number of markets with sizable barriers to entry, on the belief that, 4 is enough, 5 is enough in a number of these markets. Now, what worries me now, ex post, is, well, if the barriers to entry and expansion remain very significant, so we're still left with the 4 or 5 players, and suddenly there is a lot of this sophisticated pricing going on and parallel behavior, there is a risk that the actual outcomes for consumers in these markets might worsen quite significantly. And it's not immediately obvious what you do as a competition authority. Because, as Amelia was saying, you need proof of some degree of interaction, potentially to go after companies for horizontal agreements. And we know that's quite difficult because A, there are a number of potential cartels where people talk, but we don't have any evidence of it, so we can't go to court about it. And then there are potentially cases where people don't talk, but they are very aware of what the others are doing. There are potentially a number of mechanisms that facilitate these parallelisms, potentially same consultants, same third parties selling similar software or similar products. And that, I guess, becomes an area where you can end up with poor outcomes, but not obvious solutions. The other issue is if you suddenly start seeing some of these things and you link it back to merger control, I'm not sure as of now we have a body of evidence where you can potentially start prohibiting transactions and then successfully defending your decisions in court on the speculation that potentially that particular market structure plus the use of pricing algorithms might in future deliver poor outcomes for consumers. So I think these are all areas where obviously we all need to constantly look at the actual evidence and see what happens and learn from it and potentially adjust the way we do things. But I think that to me is one of the areas of concern.
Well, I just have to add that this type of tacit collusion is not unknown. No? It's if we look at our fuel markets in the past, we had obviously some tacit collusion there, and I guess if a market is transparent and by the internet, by platforms, it becomes more transparent. Well, the advantage for the companies to collude tacitly is obvious. So I think the idea very attractive that Andrea was pushing forward. That maybe there is one argument more in our merger control. It's not at the moment. It's a rather tough case to prove. There will be tacit collusion in the future, but maybe if we have more evidence on that, maybe it's a good argument. But in the end, to solve the problem of tacit collusion by direct action of the competition authority, that's difficult. That's difficult because that's not prohibited by law.
At the moment.
At the moment.
Any thoughts?
We're looking into the role of algorithms and machine learning from not just from a data protection compliance perspective, but also ethical perspective. And I think a lot of these principles will apply to different areas of regulation. But one principle that's been suggested is that if you cannot, someone has to take responsibility for what the algorithm does, and furthermore, in order to be accountable, they need to be able to explain to the regulator how it works. And potentially to individuals who are affected by it. So if they can't do it, then they shouldn't really be profiting from that algorithm. But then there's also the aspect of unfair discrimination, and there are risks that people are looking into of people being trapped within algorithms so that they're only able to, access certain services because they're interpreted as being within a particular category which they can't then contest, and the new data protection rules are trying to address that, but we'll see if it really works.
Okay. I will just go out to you guys, see if you have anything you wanted to say on algorithmic collusion.
So just curious, that there is the precedent in the airline industry in the US where they were using the computer reservation systems to communicate. So I will increase the price on this route in 1 month's time, let's say. And then I believe, if I remember correctly, US antitrust did come down on this. So I was surprised a bit that folks were very reserved here. So, I mean, one could imagine policies that would, let's say, maybe you would have to, you wouldn't be able to communicate your algorithm to your competitor, for instance, right? Because once they know, now we're communicating, right? And that's, so yeah, I'm surprised we had a just hands-off response there, because I could imagine certain norms that might be healthy and we would at least probably want to prevent communication, and that might mean not sharing your algorithm, so then you have some uncertainty as to what algorithm they're playing. One thought. So if you have
I think I think something like that we would be worried about, and our thought process would be that potentially in the UK context would be better potentially for us to go after it using our market investigation tools, which would be about forward-looking remedies. So looking at the problem and saying we think this is creating a problem in terms of outcomes for consumers, and we are going to try to fix some of the aspects and essentially prevent this type of communication. And that's something potentially, depending on the specific fact of the case, we'll be quite comfortable doing. The use of Article 101 and saying, you have breached the law, essentially because of the case law and because of the history of that tool, there are some constraints about using it when you don't have any proofs of explicit communication there. So again, it's very fact specific, but then it's more about the way you decide as an agency to use a particular tool to try to be effective at doing it, because obviously spending 18 months or a couple of years looking at a particular practice with the wrong tool and then ending up losing in court is not great for consumers or for the authorities. So from a substantive economic point of view, I completely share your views that this is an issue and that's something we need to deal with. But obviously we operate in a legal context, so it is about particular tool that you use to deal with. Exactly. So that was done under, U.S. legislation, and there are some differences across jurisdictions, particularly in this area of agreements and how you define these things, which are important for the specific agency. So even if the economics is the same, the law is slightly different. So I think I don't know exactly what tool the Department of Justice used at the time. I remember the case. I remember some of the economic papers based on it, but I don't know exactly what legal tool they used for that.
Well, there's a fine line between, I would say, tacit collusion, where you don't have any context between the competitors, and concerted practices. And when you have some kinds of contact that you can establish as competition authority, I would be rather bold in saying, well, we would go after that. I understood that there were contacts. They shared their algorithm or they shared their programs. So maybe this is in the specific context of the case enough to say, well, it was foreseeable that the other party would use it and that it would mean that afterwards there will be parallel behavior. So then you have a concerted practices or agreement, and that was I didn't want to be misunderstood that it's a kind of hand-off approach. It's just if it's just that algorithms that you have for yourself are kind of developing a tacit collusion idea, self-learning, whatever algorithms, then it becomes difficult in the actual law context to go after that.
It may well be that actually tacit collusion isn't quite the way to think about these things, but if you think about a standard Nash description of competition, you choose your price assuming that the other player will just, assuming that their price is given. Actually, if you know they've got an algorithm and you know exactly how that algorithm is going to respond to your change in price, then that will change the nature of competition from an economic perspective, and that could well lead to very different market outcomes. Maybe concerted practices is by far the better way of looking at this, but I think this is, I'm sure the CRS cases has similarities, but actually to have this happening on such a wide scale is quite interesting and novel, I think. So we may all need to do a bit more thinking. Okay, so...
There's a question there.
Oh, sorry, yes.
Just a quick reaction to that. I think in the computer reservation system issue, I mean, if one of the players actually owns the algorithm and then is selling that to other players that are using the algorithm, that kind of changes the nature of it. But with respect to what you were saying, Amelia, I would beg to differ slightly.
Okay.
When I teach the concept of a Nash equilibrium in a repeated game, I describe a strategy of your opponent as an algorithm. It's a computer algorithm that specifies for any given move they make, what move are you going to make, right? So a Nash equilibrium is just an algorithm that's a best response to another algorithm. So I would argue that tacit collusion, which is all about these infinitely repeated games, really, as a matter of theory, are not per se illegal, right? So the fact that an algorithm is updating based on observable information about a rival is no different than in the old days, I'm just watching a price out there and reacting to it. But here's a question for you. It strikes me that an interesting aspect of algorithms is that it's intellectual property that's valuable to me, and I don't want you to be able to backward engineer my algorithm, and I want to keep that algorithm secret. What happens if I've got a pricing algorithm, and then I decide to make it an open source algorithm? Would that be a violation of antitrust law? Communication.
There you are. That's a very interesting question. I don't know the answer.
It's a little bit, there's a parallel to signaling in context, and we have an issue there, which is sometimes difficult to grasp with the law. When you're on just outside the area of algorithms, if you just announce your price somewhere and the others just follow, it's difficult. But sometimes when you have the specific case context, it might be enough to establish, well, that's concerted practices. With open source, it becomes rather difficult.
What is interesting is it shows immediately an attention, because there is some pressure on organizations to be more open about their algorithms so that we can be more confident that they aren't biased, essentially, and that they're not having detrimental effects. But actually, the more open firms are, then yes, the more they could have these anti-competitive effects. So these areas are never straightforward. Yes?
I have a question that is maybe only partly related to the issue of algorithms, and that is high-frequency price changes as a method, basically, for example, to exploit consumer behavior and different elasticities of demand at different times of the day, as we see in the vehicle fuel market, for example. And so that you can get a situation where basically price comparison is no longer possible at all, and we get then very negative market outcomes potentially. How does that fit in this discussion?
Well, I guess under sort of abuse of dominance, that's a potential area you would look at. So if if a company were dominant in a particular market, that kind of exclusionary, potentially exploitative behavior could potentially be looked at under that. So that's certainly an area I think we would potentially look at in the specific case.
Another thing there is if prices are changing all the time, one of the things that comparison tools and platforms are meant to do is help us as consumers to make comparisons across products and therefore choose the best product for us, and that in turn drives competition. If prices are doing this all the time, that becomes a really difficult thing for us as consumers to do.
Just about algorithms. So far we have talked mostly about algorithms that are designed by humans in order to, set prices. What do you think about self-learning algorithms like, deep learning or anything like that? And also in terms of responsibility, as you talked about earlier on, would that be a concern or a problem?
Well, that's the key question, and that's why this debate is taking place now about advances in artificial intelligence and at what point we need to where we need to place that responsibility ultimately with a human being, with an entity, a legal entity or physical entity, and it's very difficult because everyone will try to avoid. Everyone will try to avoid responsibility if they can. So you put something out on the market, and then you don't want to be liable for anything that then goes wrong. But there needs to be a public debate about who carries the can. I don't have the answer though.
I think again. It's not up to now. It's not a mass phenomenon, but when it becomes more common, one has to take more care about market structure in a way. If the market structure is prone to tacit collusion, well, the artificial intelligence will soon get it, and on every side, and well, then we have a real problem. When the market structure is not prone to tacit collusion, but to fierce competition, then even the self-learning algorithm will fiercely compete one against the other. So once again, it's about market structure, and then maybe we have to think more when it's in place. I don't see that. It's not.
Okay, if we turn now to abuse, clearly there's some very interesting abuse cases going on. There's a whole question about how easy it is to prove dominance in some markets that are actually quite hard to define sometimes, and where sometimes the market power might only actually relate to one side of the market for which you're a gateway, whereas you might be actually competing actively on the other side of the market, for example, in the advertising market. So quite complex questions just around assessing dominance. But if we focus a bit more on the question of abuse, we've got abuse around a potential abuse around kind of algorithm bias, so the whole Google case with Google Shopping and kind of the whole ranking methodologies question. We've got the German ongoing case around whether there are exploitative conditions, and then there's issues, I don't know of any cases going on so far, but there's been discussion about kind of the proprietary control of big personal data by incumbents. That's come up more in a merger perspective so far, about things like joining WhatsApp and Facebook, but actually, and the recent fine by the European Commission to WhatsApp and Facebook for not admitting that they would be able to share this data. I think they just paid 110 million euros for effectively lying to the Commission about that point. So questions about this proprietary use of data and whether that could be abused to prevent new entrants coming into a market. I guess one of the questions there is abuse of dominance law really the right way to be addressing all of these complex problems, or actually are there other routes? And in that context, I thought it was interesting that I think the General Data Protection Regulation is to some extent addressing questions around the conditions that people like Facebook put in their give to consumers. So obviously some interactions there. I don't know whether you might like to say something about those interactions, Christian.
You're absolutely right. The GDPR does address this, and it strengthens the principle of consent, that it has to be informed, that it has to be freely given, that it can be withdrawn. And although consent isn't the only basis on which you can process personal information, there are other possibilities, but consent is a common one. I mean, the Bundeskartellamt probably won't be grateful for me saying this, but we're actually we quite admire what you're doing, and think that it's very interesting, and we're hoping that your analysis is successful. We don't know what the outcome will be, but we think it's very important that this clause in Article 102 on fairness of terms and conditions. It's almost been like it seems to be a sort of ghostly presence in antitrust law, and we think that it's a good thing in the current climate to try to put some flesh and bones on it. The other interesting parallel between what we're doing in data protection law and what is already established in competition law with the notion of abuse of dominance is that companies who are in a dominant position have a special responsibility to behave in a certain way, and we translate that as the principle of accountability, which is an innovation in the new regulation passed last year. And the idea there is that responsibilities become scalable, so the more power, if you like, you have, or the more risk that you are creating by processing personal information, the more robust steps you need to take in order to prevent something bad happening. And in many ways, I think that was inspired by the older tradition of antitrust enforcement. So we do think that yes, you need to have a minimum standard of fairness in terms and conditions, which applies to everybody, which is what the GDPR is trying to achieve, and also consumer law. But really, if behaviour is going to change across the market, and then it needs to, then the big players are going to have to take the lead, because the entire ecosystem is based on a revenue model which relies on tracking and often very opaque practices, so people don't know what's really going on, and really it's the big players have, we think, have a responsibility, but also they're best placed in order to show leadership here, and we hope that antitrust will have a role to play in that as well.
Yes. It's the discussions are sometimes difficult that we have on our case, because some people say, well, it's not up for the competition authorities to enforce privacy laws. It's you have to care about markets and not about other things. And I would affirm that it's not the task of competition authorities to enforce data protection rules. But if there are business relations and there's a law for dominant companies, well, if you're dominant, the terms of conditions you impose on the other part must be kind of fair. Then this type of fairness has, of course, a relation to laws outside the antitrust world. So we have unfair contract terms where you have values, what is fair and legal and not, and then you have data protection law where you have something what is fair and legal. And so when you have to assess the fairness of a condition, and this is only for dominant companies. Well, it's that, and then that's why it's antitrust law. It's they have to refrain from imposing unfair conditions on their counterparts. So I see it's not our business to enforce directly those parts of the law, but of course the values behind those laws have to be reflected as well in antitrust enforcement. So therefore I see a strong interrelation, and that's why we are cooperating with all the stakeholders, so with the consumer protection associations and the data protection agencies, because we have to learn about it, but these values are there. And if we add that in the German jurisprudence we have rulings that not at all in the data protection area, but in other areas, in unfair contract terms area, that the infringement of these extra competition laws might constitute an infringement of antitrust law. Well, then I think it's we can go forward and see whether it's an abuse or not. When you just from the personal experience, when you have a dominant or when you have not a dominant, but when you have a strong network with direct network effects, and they just change their rules, well. Most of us would just stay because, well, we want to stay in the network, and that's what I see as the classic economic power on the consumer. If you can't change, if you have no choice, and competition protection is about protecting the choice of consumers. If you have no choice, then antitrust law has its say, and therefore I see that we are not in the wrong playing field, let's say, let's put it this way. And there are other interesting connections with the data protection part. You just said that consent must be freely given. Well, is consent freely given when you are acting with a dominant undertaking? interesting question. There are strong relations, strong interrelations, and well, we'll see.
Are there any questions in the area of abuse or comments that people would like to make? Yep.
Hi. So thank you very much for your really enlightening discussion. What I wanted to ask you about was, Andrea had mentioned the FTC a little bit. Obviously, a lot of these big platforms are based in the United States, and of course, the United States has their own regulators as well. And so what I wanted to ask you about is, what is the state of play in terms of regulatory cooperation between your institutions and your American counterparts? Thanks.
That's very good. I mean, I was talking to our colleagues at the FTC just a few weeks ago in Portugal. The type of cases and the type of issues we're worried about are pretty similar. And in many ways, we're certainly very interested in what the FTC is doing at the moment. And I think they are quite interested in what the European Commission and the large national authorities in Europe are doing as well. So there is a lot of two-way communication. There are secondments. And certainly it's, I would say in that area, cooperation is really important.
Well,
I guess you're in the same place.
I would just add, well, we have these international networks. I don't know, some of you may be aware of that. We have the ICN, and that's also a meeting in Porto, where we meet each other. We discuss issues with our colleagues, specifically, of course, with our colleagues from the United States. Then we have the European network, the ECN, which is much more closer, of course, because we can share confidential information. We discuss really on specific cases, even when they are not public. So there is a lot of exchange, we follow quite closely what our colleagues are doing.
Sadly, the ECN may be blocked to the UK going forward, but we hope not. But we will see where we get to on that. Okay. I'm going to now take us on to consumer policy for the last half an hour of the session. Obviously, we've touched on consumer policy and data protection anyway, but with a bit more of a focus on the consumer protection aspects here. Christian, I don't know if you want to say anything by way of opening.
Yes, well, I think you wanted me to just introduce who I work for. It's the European Data Protection Supervisor is It's an European Union body. It's separate from the Commission and the Parliament, but we're independent supervisor of how the 60 or so other EU bodies and agencies handle personal information. But we're also very active in the policy area, so we advise the different institutions on legislation, proposed legislation, and we cooperate with all the other data protection authorities around Europe, 28 of them for now, and we try to take a strategic long-term view on what's happening. I think you also were interested in what's just a quick overview of what's happening in data protection law. Well, we've touched on it, but I think the heaviest lobbied piece of EU legislation ever was the General Data Protection Regulation. It took 4 years to negotiate. There were thousands of amendments, largely put forward by private sector lobbyists, but it was finally approved and adopted last May, almost exactly a year ago. And there are a number of innovations in there which are relevant for this discussion. So things like the right to be forgotten, which is not a phrase I like very much, but anyway, it's basically giving people the ability to say no. I want you to delete that information because it's not accurate, or it's infringing my privacy. We mentioned consent. There are rules against profiling, automated profiling of you as an individual. There's a requirement to design things with data protection in mind, and there's also a provision for class action, so you can, depending on the member state in question, you can bring a collective complaint against a company which has violated rules and the harm it's caused as a group. And then at the moment there's something called the e-privacy regulation proposal which is going through, and that's all about confidentiality of communications, which traditionally was envelopes and letters, and then it became telephones, and then it became emails, but now they're going to broaden it to all providers of communication services, so-called over-the-top services, so Skype, WhatsApp, Facebook, all of them will be covered, and they will have an obligation to protect the confidentiality of those communications. So that's all happening. It's very much in flux, and it's very politically hot. What we're doing, which I think is relevant for this, one of our big projects, which I'm involved in personally, is something called the Digital Clearinghouse. What we are trying to do is bring together regulators from different fields who are responsible for what's happening in the digital environment to talk to each other and learn from each other. One of the tasks is for we think is for data protection authorities and consumer enforcers to be more active in supporting antitrust bodies, antitrust enforcers in what they're doing, and they're trying to understand what's happening in the market and the impact on the consumer. I mean, in terms of what's happening, the reason why we think this is really important is because we're basically in a transition phase where the rights and interests that we have taken for granted in the sort of real world, the physical world, are not really being reflected yet in the online world, where almost all our lives are almost have migrated almost completely, and there is a notion that privacy isn't really so relevant once you go online, but that's really a myth, because the example that is often given is Mark Zuckerberg, who once said that privacy was dead, I think. So he spent hundreds of millions of dollars buying a very nice house, but also the plots of land around it. And that wasn't just for his convenience and comfort, it was because he was trying to safeguard the privacy of his privacy and that of his family, which is entirely legitimate. So everyone cares about privacy, and surveys indicate that young people care even more. There's an anecdote of, I don't think there are any teenagers in the room, or maybe someone's got a teenage child, but my goddaughter is a teenager, and there's a beautiful article in Wired this month where they interview teenagers and how they use platforms and social media. And two really interesting things. The first is that a lot of them are completely addicted to Snapchat, and they the reporter was actually interviewing this 17-year-old via Snapchat messaging, and the reporter said, "Is it okay if I keep the messages?" And the initial response from her was to laugh, say, "Ha ha! The whole point of Snapchat is that the messages are instantly deleted." Now, when she grows older, she'll realise that actually they're not deleted. They're no longer seen by friends, but that data is valuable to the providers of the service. The other thing that came out from that article is that teenagers are extremely stressed by what's happening. I mean, they're addicted to these applications and networks. If an old picture appears on Instagram because someone has liked it, that's extremely stressful for them, because they don't want to be reminded about how they used to look. And it sounds trivial, but there are actually cases of suicide in different countries because teenagers have become so stressed about what's happening in these online areas. So that's why it's really important. People are feeling alienated from their online selves and the data that's out there. They feel like they don't have any control over what happens to data about them. And now, I mentioned earlier, the notion of filter bubbles and fake news, people are sensing that divisions in society are actually being exaggerated because people are being tracked. I've experienced it myself with the Brexit referendum last year. Like my Facebook timeline indicated that something like 95% of my network were Remainers, which was clearly not the case, but that was my bubble that I was in, and so I was just seeing all of these updates and just getting angrier and angrier. That's what's going on. The third reason why we think this is very important is the second reason this is very important, second of three reasons, is that there is this convergence of market and informational power. 10 years ago, the top 5 companies by market capitalization were, I think there were some oil companies in there, General Electric and Microsoft. Now, it's the latest figures are that the top 5 are are Microsoft plus the GAFA, so it's GAFAM now, and there is a need to make sure that these are companies which have grown up very rapidly, and they've often been in the margins of regulation, and they've often positioned themselves very skillfully to avoid any regulation. So now is the time for them to be accountable for what they're doing. The third reason this is very important is security. It's a fact that all computers are vulnerable. The WannaCry virus, which hit a couple of weeks ago, is an example of that. No information which is out there stored in the cloud is safe. There's been a rush to connect everything, and you speak to computer scientists and security experts. There are 3 important elements. There's speed, there's cost, and there's security. And security tends to be sacrificed, and that's where we are now. So there needs to be an engagement with how to create an obligation for things to be safe, but also look at principles like data minimization and making sure that there are offline options so you're not completely vulnerable. So to conclude, what we're doing with the Digital Clearinghouse is people have started talking about post-truth in politics, but we're starting to talk about post-price, because there is a deliberate decision by the pioneers in Silicon Valley was to drive services to free. So most people interacting with these services, they didn't have to get their credit card out. What that has meant is that regulators are now trying to adapt to that. You see this in the competition world where, as I think Konrad mentioned, that the merger criteria, the thresholds are being adjusted so that it can take into account the value of the data which is held. We've had the Digital Content Directive proposal, which is going through the European Parliament at the moment, quite controversial because it has contained the idea that you can pay with your data for a service, which we have contested in an opinion recently, and then you've got the General Data Protection Regulation, which applies explicitly to all services, including ones which don't cost anything. So that's all. I mean, the Digital Clearinghouse met for the first time on Monday. We had a number of regulators in the room, and information is on our website about what they agreed to do next and what they were going to focus on.
Lots of really easy issues to solve there. That probably was a list of all my biggest worries in the world, pretty much. So very, really interesting and important stuff. Andrea, would you like to say a little bit about what the CMA has been doing in consumer protection?
Yep. Yeah, so just a couple of things in the interest of time. We, as I was saying, we're very happy to have both competition and consumer powers. And the way we run the agency, we're fairly integrated. So a number of issues and complaints and concerns come to us, and we start looking at them through the various lenses. And it's not obvious to us for a while whether we should then try to go after some of these issues using competition law powers or consumer powers. So I think that's a very important area, and in many ways, I think the FTC works in a similar way. So we've been quite active on the consumer area. We've been quite active in the digital space in the consumer area. A couple of cases we've done over the last couple of years I would like to mention. So the first one is the area which, to be honest, we kind of copied a bit from the FTC, of online reviews and endorsements. So that's an area that, again, has been growing very significantly. And there are essentially two separate parts to it. So one is the endorsement. So if you look at Instagram or some of these very successful social media platforms, there's been an explosion of influencers. So people paid in various ways, in a fairly murky world, by companies to support their products. And the concern that initially the FTC had, and we ended up having exactly the same concern, was that it's just not obvious to us, it's not obvious to my son, it's not obvious to a number of teens using these platforms, whether celebrity or minor celebrity X is supporting a particular bag or a particular pair of football boots or something else because they've been explicitly paid for it, or because they like it, or because they've been offered, a trip to the Seychelles to support that product. And so we thought it was quite important for us as an agency to try to bring clarity to this, the same way as in traditional world, advertising has to be clearly labeled. So we went after a number of companies and individuals, and we sent many more letters to others to try to really improve the situation in the UK market. We don't have powers to fine companies and individuals at the moment. That's something we've been discussing with the government, and the government has recently said that they're minded to give us fining powers, like a number of other agencies have, because we think that's quite important in terms of deterrence as well. Because at the moment, essentially, we can only go to a company and say, please stop doing it. And essentially, there is no penalty or reward between companies who actually do the right things and others who just ignore it and then eventually end up doing the right thing when we go after them. So we don't think the system is quite in the right place. The other area is reviews, and again, probably most of you and in this room use review sites. I mean, obviously TripAdvisor is an example of it, and there are many more. So we think that's a very important tool in terms of empowering consumers on the demand side, getting consumers engaged. Most of us probably, you go as a tourist to a new city, and you can look, you are interested in looking at review sites for hotels, for restaurants, and various other things. Now, if it turns out all of this is incredibly biased, it just doesn't quite work, because obviously people start losing faith in them. So when we start digging into it, and again, we followed activity by the FTC in the US market, we found quite a lot of fake reviews, and we found companies who essentially whose business was to write fake reviews, which obviously we're not very impressed by. And also we found that even big names had mechanisms in terms of reporting reviews which were biased. And obviously, as you can imagine, we're biased in terms of over-sampling the positive reviews and under-sampling the negative reviews. So again, that's an area we went in, and we did quite a lot of work in it, and we think the market moved into a materially better place. And that's potentially an area we're going to come back to. And again, I think fines should be part of it, because I think activity by us plus fines, I think we could really get the market in the right place. I think at the moment there is a bit of constant activity needed for us there. The second area I would like to mention quickly is cloud storage, which is another area which is important. I guess probably everyone in this room subscribes to cloud storage services. And again, looking at the UK market, when we started looking into it, what we realized was that this is a market that expanded very quickly with lots of big names. And again, the commercial practices were not great. It was not an issue of lack of competition. There are quite a few suppliers, and it's a fairly fragmented market. But again, when you start digging into it, we realized there was lots of bundling, sales practices which are not great, and also terms and conditions in the contracts which are not great for consumers. So issues like auto-renewal of contracts, which were pretty opaque to consumers when they sign up to that. Quite a few providers quite happy to change prices and storage limits kind of way through contracts. So there are quite a few things when we start looking at them through the lens of consumer legislation we're not happy with. And again, we managed to move the industry into a better place. Again, we couldn't give fines. We think that we're in a better place now. And again, I think going back to what I was saying earlier, to me, that's an example of an area where the average consumer would like someone to deal with it. I don't think people want to really, if you go to a store or you buy online a PC and you buy various other things and you are setting it up, you're doing a number of things and you have cloud storage contracts coming with that. I don't think people want to spend hours trying to look at exactly all the detailed terms of that cloud storage contract. They want someone to make sure that there is a degree of fairness to the standard contract terms. Obviously, minority of consumers might engage with it and try to make some changes to it, but the vast majority of consumers think that they just want to have a sensible, kind of fair terms coming with it. So we think these are quite important for an agency like us, where sometimes, in some of these competition areas on digital, it can be quite difficult for people to grasp exactly what we're doing, and sometimes, we're going after companies who are excluding other companies, and it's not that easy for consumers to see the direct impact on them. And so as a complement, these cases like cloud storage or reviews, I think they're quite easy for people to get. When we say we've intervened, we've looked at that, these are the things we have changed, and now the terms we think are better, and you just move on. So, and quite interestingly, we are increasingly mixing the staff working on these things. So we have the same economists and lawyers working on potentially sometimes on competition cases, on consumer cases. We think the cross-fertilization is quite useful. And obviously, particularly on the consumer side, there is a big network going on, both international agencies, other regulators domestically, data protection agencies, the Information Commissioner's Office in our case. And that's also very important for us. So we spend quite a lot of time taking care of these relationships as well.
Thanks. Konrad, I know that you're in a more limited position to comment on this because the BKA is only just basically getting this power to look at consumer issues across markets, but I don't know if there's any comment you want to make now?
Well, yes, of course, during our different proceedings, we came about to see where there are deficiencies as well on the consumer protection side. During the various proceedings, even Facebook, but again, I don't want to go into Facebook because it's a current proceeding. But of course, there you can, in this area, you can see there is private enforcement in Germany. Well, the institutional landscape is different. That's why we are looking very closely what our British colleagues are doing. And in the very moment, the landscape is as such that the consumer associations are doing the job and bring it before the civil courts. But the general feeling was that there might be lacking some public enforcement as well because of investigatory powers of the authority and as well maybe the sanctioning powers that are different to add the system, not to really change it, but add on top some authority. In the legislative process, it was reduced to a kind of first step. While we first get the power to do sector inquiries and to look into consumer protection things as well. But we'll see. We'll see whether we will have the powers as well. And then, well, yeah, all these things, our European colleagues, where you have this combined power of consumer protection and competition enforcement, you see that there is room for action. If we see the price comparison sites, well, we just did it by accident by having another enforcement proceeding in the antitrust area, and we thought, well, how reliable are these price comparison sites? And there we got some doubt. It had not any influence on our antitrust issue, but if we were as well a consumer protection site, one would go more into the detail like our colleagues.
In fact, I wanted to raise the price comparison site issues that, in fact, Andrea didn't mention, but are also being considered by the CMA, but I think more widely. There's some interesting issues. Essentially, price comparison sites provide this useful comparison tool for consumers. The question is whether their incentives or their representations are absolutely well aligned with what consumers need. bearing in mind that consumers don't actually pay for the comparisons normally. It's the suppliers who pay to be on the price comparison website. And I don't think that's always, well, I'm sure it's not very clear to consumers, although they probably know it in their hearts, but it doesn't necessarily matter. The question is whether actually it affects the service that consumers are getting in a negative way. So, for example, if you get a ranking of, for example, hotels, if that ranking is affected by how much the hotels have paid, with those hotels who have paid more being higher up the ranking and those hotels that have paid less being lower down the ranking, but consumers aren't aware of that and just think, oh, somehow these hotels at the top must be better in some way. Is that a problem? Is that a problem from consumer side, because from a competition side, because consumers might be making the wrong choices in some sense? Is it a problem from the consumer protection side, because consumers aren't aware that their choices are being manipulated potentially in this way? Is it an issue that can be solved by greater clarity, so requiring that it's very clear to consumers whether rankings have been sponsored, explaining to consumers what the business models are? Or is it a problem where actually you need more direct regulation? And I know that those sorts of issues are being discussed on both the consumer and the competition side in some jurisdictions at the moment. There are similarities to financial advice, where financial advisors used to, in the EU, potentially their advice would be distorted towards the products where they most made the highest commissions. In the UK a while ago, and now under the MiFID II, and I can't remember what it stands for, but an EU directive, it is no longer possible for financial advisors to receive commissions that might distort their advice in that way. Question, if they felt the need in financial advice, should something similar occur? What are the risks there in the space of price comparison websites? So we've got almost no time, but we've got 5 minutes. So general consumer protection comments, yes.
If Google sells my personal data to Amazon, they will need my approval for that under the General Data Protection Regulation. If Google buys Amazon, the effect will be the same. The personal data will be merged into one entity. However, it is not a transaction on personal data in that case. Thus, the regulation on protection of personal data would not apply. It would be a simple case of merger control. The test for merger control is whether there is the creation or a strengthening of a dominant position. Now, this can be the case, but it is of course dependent on very different facts from the protection of personal data. I wonder whether there is a gap, and I would like to ask our panelists whether we have to fill that gap.
I mean, I think the test is, so our test is substantial lessening of competition, and the EC test now is a sort of significant impediment to effective competition. So I think the test, in my mind, for merger control is sufficiently flexible to capture these potential concerns. Now, whether in practice, as an authority, when you have these novel issues, you feel confident that you have enough evidence to potentially block a transaction or ask for substantial remedies, I mean, I think that's a big question. But as I said before, I think merger controls, we know, is a very flexible tool. And I think as long as we constantly learn from the markets, from the data, from the evidence, I think we can be bold if the evidence is there. You know, earlier this year we prohibited a transaction in the UK, which was a vertical merger of platforms in the sort of the trading of energy contracts in Europe. some of our legal colleagues, when they looked at it, they thought, well, it's a fairly novel case. Are you comfortable? Is there enough case law for that? And we said, look, we think the economics is pretty robust on this. We think the evidence from the documents and from the data is sufficiently robust. And, we then won in court when that decision was challenged. So it is case specific, but personally from a UK point of view, I'm not worried about a gap. I'm more worried about our sort of R&D internally and as an agency to make sure we can fully grasp and understand some of these novel aspects of cases.
Well, I think there might be a gap, but not in competition law. Because, well, if you have two small companies with your personal data and they merge, there is maybe no distortion at all of the competitive process. It's just a merger of two minor players with no influence of the market. But of course, if it was just the sale of your data, it would fall. Even if there's no market power, it would fall under the directive. And if they do it by a merger, well, you have maybe a hole, but not in the antitrust area. But if you don't want this happen, it must be regulated in the privacy laws, not in competition law. Yes, that's not my business.
That's a crucial question. A couple of things. First of all, I would challenge your premise that if there was a merger, and there have been mergers in the past, like the Facebook WhatsApp is the classic example now, where they said they wouldn't be able to combine the data sets, and then they tried to last year. And that's why data protection, that is a breach. That is a potential breach of the data protection rules, and that's why there is a coordinated investigation now by the data protection authorities. So regardless of whether or not the merging of the data set occurs through purchase or through a merger or through a company deciding to change the purpose for which they're using that data compared with the original purpose, the data protection rules still apply. But I mean, is there a gap? We think that there is. We think that for mergers there needs to be a longer term perspective of what the impact will be on the consumer, on the individual of that merger in the digital environment. So, we're agnostic on whether it should be the antitrust authority doing that, because we don't believe that the antitrust authority should enforce privacy rules. But it could be that the antitrust authority, in doing their analysis of a merger, that they consult relevant bodies like DPAs, consumer authorities, and then they integrate that into their merger decision as part of it could be like the conditions that they apply, or the alternative is they do their purely economic analysis of the impact of the merger, but then in parallel there is a coherent response from the data protection community, from the consumer bodies, so that when the merger decision takes place, there is also, like what the FTC did to an extent with the Facebook WhatsApp merger, there is a statement to say that we're going to be vigilant and we're going to hold you to account for what you do as a merged entity. And I think with the Facebook WhatsApp case, there was one authority, one data protection authority, a Hamburg authority, I think, in Germany, the regional one, which made a comment when the merger was cleared in 2014. But we think that data protection authorities should be doing a lot more. But then the final sort of footnote to this is, again, like, what do we mean by, what is the value of this transaction? And if with WhatsApp and with now LinkedIn, these are $20 billion transactions. What is it that's driving the value there? And it can only be the personal information there. So there are questions there which need to be answered by the regulators, and we hope that they will do it more coherently in the future.
Thanks very much, Christian. Well, very good question. Actually, an issue I'd not thought of. So I'm afraid we're going to have to stop it there. We could. I would thought that two hours was going to be too long for this policy roundtable. I now want like 4 hours, but you probably want your lunch. So I think there's been a really interesting discussion. I won't try and even draw conclusions because it's been too wide-ranging, but I hope you found it as enthralling as I have. And I think you need to be back here at 1:30 for the afternoon sessions. Thanks very much.